Sure. I'm Jim Love. I'm an attorney in Tulsa, Oklahoma. I've been practicing since 1984. I graduated from the University of Tulsa. I practiced for 5 years in California, and that's somewhat important because that's how I got involved in the issue. I'm licensed out in California and practiced there for a while. The person that got me involved in the issue is my uncle, who is a dentist in Los Gatos, California. Jim had a patient who had gone to another dentist, had something called an occlusal equilibration, which is a grinding on the surfaces of the biting surfaces of the mouth. And the grinding was mostly on dental amalgam surfaces. This gentleman, a chiropractor, became very ill just a few days after that grinding procedure, and ultimately developed what we think was Guillain-Barré. I didn't know that when I took the case, but that's where we landed. So my uncle knew I was involved in toxic tort defense work, not plaintiff's work, but I was talking of leaving the firm and had actually asked my California firm to consider taking that case. Ultimately, I left and took the case with me. So that gentleman's name was Hank Tolhurst. He's still in Campbell, California, if I remember correctly. And he was very, very ill. I was led to believe initially by some consultants that we talked to that he was intoxicated by mercury. And that was the basis on which we took the case. The case proceeded ultimately. There are all these evidentiary challenges that you can raise against the opinions of expert witnesses that we proposed to use at trial. Those experts have been deposed in the course of the discovery process. And there was this challenge, and the challenge went to the causation issue. A very, very typical response you get from defendants who have been accused of intoxicating a plaintiff. So that issue went to hearing, evidentiary hearing, and we lost. And I think the reason we lost is that in the course of discovery, our causation experts really changed their mind. They changed their mind and concluded that, well, Tolhurst was suffering from mercury intoxication, but really he had contracted Guillain-Barré disease, or Guillain-Barré syndrome, which is an autoimmune illness that can be caused by any of a number of antigens. Some of those antigens have been identified. There are certain bacteria that can induce a Guillain-Barré autoimmune reaction. It was our contention that mercury had caused this reaction. And I became convinced in doing my own research on this issue that mercury, in fact, could induce Guillain-Barré. Unfortunately, the vast majority of the literature I was reading was written prior to 1920, a point in time in which we still had not named Guillain-Barré syndrome. Guillain-Barré syndrome was actually named in 1927. So these papers that I'm reading are associating an exposure to mercury and identifying this illness that is described as Guillain-Barré is described, but they're not calling it Guillain-Barré, of course. When we went to hearing, the judge was very interested in why I couldn't find more recent literature associating mercury with Guillain-Barré. And I think the reality, and we did have some, but the reality was most of this literature is older because mercury was in everything back prior to 1920. It was in medicinals, it was in creams, it was in diaper rash ointment, and so there was a proliferation of instances where people were exposed to mercury and then had these adverse outcomes. The ADA filed a preliminary motion in that case, and the essential argument to the court was, we're just a trade organization, we don't owe a legal duty of care to dental patients. You know, frankly, I didn't associate a lot of consequence with that statement. That was a sort of legal statement I would have expected to see from the ADA lawyers. But when I went back to the academy, an organization full of dentists, and said, here's what the ADA said in response to my lawsuit, they were astounded. They couldn't believe that the ADA had taken that position. And in fact, apparently so many dentists were astounded, that news traveled fast, and so many dentists around the country were astounded by that statement, that position continued to appear in papers across the country. In fact, I saw some dentists as recently as 2 or 3 years ago. This is years and years and years after the Tolhurst case concluded, telling a newspaper in California that they dropped out of the ADA and quit placing amalgam years and years before in direct response to that position by the ADA. That position, which ended up being fairly well publicized, sent shockwaves through the dental profession. It's fascinating to me that it could have that kind of impact. And apparently the ADA felt the impact of those shockwaves because for years and years, they had posted on its website, the ADA's website, a statement very defensively responding to the position they'd taken in that lawsuit. And they tried to explain, gee, this is just one of those crazy lawsuits, and gracious, we had to do something to get out of the case. Don't hold us responsible for what we say. So going back to the ADA's role in all this, I didn't know at the time I was responding to the demurrer, that's what it was, that's what they're called in California. It's a motion to dismiss, effectively, at the very earliest stage of the litigation, on the ground that there's no legal liability based on the facts that are alleged in the complaint. Well, they had filed this demurrer, and they made this statement that they didn't know a legal duty of care to patients, and so now it's my time to respond. And you know what? I didn't have a very good understanding. This was the very first case I'd handled. I didn't really know what the ADA was doing out there. They said they were a trade organization. I didn't have any information to argue with that at the time. And looked at some of the cases that the ADA cited. I very distinctly remember a swimming pool trade organization that it was a swimming pool manufacturer organization representing swimming pool manufacturers that had been sued when a kid was killed falling in a swimming pool or something like that. And the argument of this trade organization was, we don't owe a legal duty of care. We just represent all these manufacturers, and we can't be held liable when a kid falls in a pool. And the court agreed with him. And so I thought, gee, that looks a whole lot like the ADA position. And I found some contrary things, and I made my argument, and I lost. The ADA was dismissed in the Tolhurst case. And so the Tolhurst case proceeded on against the other defendants, who were a dentist that did the equilibration procedure, and a bunch of dental amalgam manufacturers. What I found out in the ensuing years is I just didn't get it. If I'd known then what I know now, I might have been more successful in defending that demurrer. And the reason I say that is the ADA represented to the court that, gracious, we don't have any responsibility for these outcomes. We just represent the interests of the profession to the public, and not much more. In fact, the ADA is the profession of dentistry. They set the standard of care. They set the standards for accreditation of dental schools. They set the standards that are adhered to by dental boards. And in fact, the dental board members are almost invariably staffed by members of the ADA. The ADA staffs the dental division of FDA. They so pervasively control everything that happens in the regulatory context throughout this country that they are firmly in control of all decisions that pertain to the profession. And so for the ADA to say that they're just out promoting the interests of the profession of dentistry is a fraud on the American public. It's not true at all.